Okay, good morning, everyone. Welcome back to whatever the week number is. It's a busy week. We're going to be on the floor a long time today. We're going to go into the afternoon. So Lori is once again rearranging the schedule. And working her magic once again. I think you are deserving of a gigantic magic wand, Lori. These last couple of weeks have been trying. Okay, so the first thing we're going to do is take up the amendment to 861. And Katie, if you want to join us, it's very difficult to understand, and I want to make sure that we fully grasp it.
It's so complicated.
Our email exchange on Friday was definitely complicated.
That was funny.
No, it wasn't.
I'm still logging into Zoom.
No, that's okay.
Hilarious.
It's okay. We have it in front of us, so you don't need to bring it up.
Oh, okay.
That's fine.
Great.
It's a one pager.
I
mean, one sentence, yeah.
Meeting within Office of Legislative Counsel. So you are familiar with H 861, which is creating the ADA coordinator position. There is an amendment from Representative Noyes that would add to the duties of this position, and that new duty would be to apply for grants and accept donations to support the work of the coordinator's position. So it wouldn't just be state funds. The coordinator could apply for other funding opportunities.
Anybody have any questions?
Sounds like a good idea.
Yeah, I agree.
That's what the Secretary of State's office said when they contacted me about it. Said, we're following this. I'm like, oh, okay.
And it's also mirrors what we did in H 841 on March 13th, which is the animal welfare bill that has very similar language for that as well.
Great. Thanks, Dan. Thanks for taking the lead to do this. So we need to do two things. We need to do a straw poll on 861 and then just a straw poll on Dan's amendment, since I think that I believe that we have jurisdiction on this, and even though it was done in a different committee. So I would like to see a show of hands. Just remember, just reminding people what it is. 861 is the ADA coordinator position in state government at the Agency of Administration. There was a amendment by House Appropriations, which is this language that we saw previously that essentially says authorizing the position if the funds are appropriated. So I still don't know the answer to the if, but we're prepared. So could I see by a show of hands those people who support H 861?
And just for the record, I was not present for the testimony, but I read the bill, so I feel I can still vote on it.
Okay, thank you. So that's 902. And then a show of hands, those who support Dan's amendment. Again, 902. Okay. All right. Thanks so much, Dan. And thank you, Katie. Okay, now we're moving to pre-K. This is in flux. Do we have confirmation from JFO that they will be able to be here on Wednesday? Yay.
If they're up for it. If we're available.
If we're available, right, I know.
Just for a quick clarification, will I report the straw poll on the bill or just?
No, you'll just do the amendment. She'll look to me for the.
Fantastic.
And the latest version of the pre-K bill is from Thursday, if you want to look on Thursdays.
And that's 3.1, right?
That's the one, that's the latest one.
That's
4.1. I'll send it to you right now.
okay. All right, I wrote all my notes on 3.1.
Sorry.
That's all right, that's all good. We'll have other versions by the time I get it through. Trust me. Okay, so version 4.1 will appear on our webpage momentarily. So since it's not on our webpage, if somebody can put it on the screen, that would be good.
I'm moving as fast as my computer will let me.
I always say we're sort of at the very end of the line when it comes to Wi-Fi, so things take longer on Route 46.
Beth St. James, Office of Legislative Counsel. This is much better than the mezzanine.
Ah, all right.
Better.
Well, they have to have something that's crappy over there.
If you want to see an example of slow movement, if you read the Digger article about red clover and all of that stuff,
Mhm.
it's like, well, that all happened a month ago. Do you have any update?
It was on, WDEV. this
Oh, they
morning,
picked
too.
it up on.
Yeah. And I'm thinking like, no, that's kind of old news.
Yeah. I guess if people haven't heard before, it's new news.
It's new. So they're
But
reporting
some
on it.
stuff has happened since
In the
then.
meantime, right, they didn't have the latest, let's just put it right. Okay, so, great.
Okay, so we have draft 4.1. I forget, did we have this key in there last time?
No,
So yellow is new policies or new changes not yet reviewed. And then green is a policy decision point, either something you were talking about but didn't make a decision, or you've asked to flag. So no changes, but maybe something we need to come back to.
okay,
So do you want us, I left early last time. We've made a couple changes to the language that we walked through, but we didn't make it through the full draft 3.1. Where do you want to start today?
let's, because I have additional notes on stuff we've been through.
Okay.
So why don't we start at the beginning again? Unfortunately, it's partly because, while we understand the private world, we don't really totally understand all of the education stuff. And so mine is probably more questions than changes.
We can just move
And we
quickly
can
where
move
we
quickly,
already,
right,
we
right.
already did.
So, and so you change that back to not yet enrolled.
I'm just gonna keep scrolling until you tell me to stop.
So I have a question on definitions. So this is my paranoia. I'll be upfront about that. And I started to express it last week around the use of the word tuition. And I am just wondering if, in this case, we need a definition for tuition that says it's equal to the categorical aid per student.
When you say categorical aid per student, are you referring to the foundation amount in Act 73?
No,
What are you referring to?
because it's gonna, I shouldn't so quickly say no, because the intent would be, so what we understood from AOE when they testified was that other categorical aid that exists now is not part of education cost. That is on top of.
I did not review that testimony, so I don't want to comment, play a game of telephone.
Right.
There are many, we call them categorical aid. There's no definition in the definition section for your education finance chapter in Title 16 that says categorical aid is. It is a term that we colloquially use to describe those payments that come off of the top of the ed fund. Universal meals, adult education, some CTE funding, transportation grants, et cetera. I don't think you need to define that term. The way chapter 133 is written in Title 16 is that it basically says, here's your ed fund, here's the allowable uses of an ed fund. And one of those allowable uses is any of the financing statutes in Title 6 in that particular chapter. So the grant that this draft is creating would live in that chapter and automatically become an allowable use of the ed fund, and would automatically come right off the top of the ed fund, the way that education finance works.
And that's what AOE does not want to have happen. So they don't want it to be. The way I understood the secretary's testimony was they weren't opposed to categorical aid as long as it was included in the cost of education. So not like universal meals, for instance.
So I think this is where it's, I have to be very careful with what I say. I am not your money gal. I am not JFO. I'm just someone who spends a lot of money to go to law school. I haven't taken a math class since the 90s. I have not reviewed that testimony.
Yeah.
I would have a question, I'm not gonna say concern, I would
Yeah.
have a question as to whether the testimony that AOE gave is aspirational as to what their policy perspective is.
Yep.
Or if it was taking into account the changes that were made in Act 73. I think you can include, so right now, pre-K is included in your overall education funding payments, right? It's in your per pupil spending.
Mhm.
The policy choice you have made in this draft is to pull it out of per pupil spending and put it into a categorical aid grant. I think it is an open question based on all of the testimony I heard last year during Act 73 and the testimony I have heard this year as to whether the base amount you passed in Act 73 included costs for pre-K education.
Mhm.
I don't know. That's a question for JFO, for Julia and Ezra. If the base amount that you passed in Act 73 included costs for pre-K education, then I think it would be a question for JFO as to whether that base amount needed to be adjusted to take into account your categorical aid grant. I don't know.
Okay.
I think it is a policy choice for you to make as to whether you want funding for pre-kindergarten education, whether that's just for public and private, just private, whatever it is, to be included in the base education amount in the foundation formula, or if you want it to be a separate categorical aid grant. I believe that is a policy choice for the legislature to make and not the executive branch.
Right. And I guess my question is, can it be considered in the foundation formula and still be a categorical grant?
Yeah, so the foundation, yes, but maybe not the way you're thinking.
Yeah.
So the foundation formula is just your base education payment amount, and it captures certain pieces of funding, certain parts of our education system. There's the base education amount, and then there are weights for different district
Mhm.
demographics and student demographics. It is a policy choice what you include in that part. What's coming out of the ed fund in general is more than just that base plus weights, right? There's the education. Right now, our current financing system has a weight for sparse and small schools. The foundation amount moves that, or the foundation formula moves that from a weight to categorical aid. Transportation in our current funding system is a categorical aid. It's an open policy question for how to include that in the foundation formula. So the foundation formula is one piece of financing the overall system. So I think it's a question. I think I'm wondering if what you are asking is, do you include pre-K in the base amount plus or weights? Or does it come out of the ed fund, but just as categorically? Those are two separate policy choices.
Yeah, I'm understanding. And I think what I guess I would say, probably whatever we say here is probably going to be subject to modification, particularly in Ways and Means, as they think about this. me personally, I have, sort of one thought, but for two reasons, that, I am still liking the categorical aid notion in terms of, you know, what we pay. And that being sort of a set amount that's not too variable. So that it's easier to track and it's easier to assure that private and public get paid the same. And then my second thing is, in order to continue to send the message in education that early education is part of the whole, not just K to 12, but pre-K to 12, that it should be included in the cost of education. So therefore the foundation formula, the foundation payment or whatever, however that calculation is made. Yeah, yeah.
Where is special ed? Because special ed also ought to be part of fundamental education. It's not something outside of special. We want that
It is, but we're
message
not
as
gonna,
well.
but we're not.
No,
going
I
down
know,
that
but I'm
road.
just thinking parallel, you
Yes.
know.
Well, it's.
But it doesn't parallel because
It doesn't parallel,
it doesn't go
right.
the way I would, I would
Exactly.
join with you.
You and I would agree,
Yeah,
yes,
yeah,
but.
okay, but they don't.
It
do
doesn't
that.
go that
All
way,
right,
right? Yeah, we're not gonna go to that, except for, I know we have to deal with Triple E. All right, so, is your, advice that we add that to the JFO conversation?
Yes, and I think I probably misspoke. To be generous to myself, maybe I just wasn't as articulate enough as I could have been. The foundation formula that you passed in Act 73 that is contingently effective on a bunch of different things happening did keep the base for pre-K or the weight for pre-K the same. So it technically, if the foundation formula were to spring it to life on July 1, 2028, without any changes, you would still be funding pre-K through the base amount plus a weight for pre-K students of the current weight, which is negative 0.54. The intent language of Act 73 says it is your intent to make updates to pre-K.
Mhm.
So,
So it's included in the, it's included in the calculation that was preliminarily made for the foundation formula amount.
I can't speak to what was included in the base,
Okay,
or what was taken into account in the base. I think that would be a question for JFO. I do
Okay.
not want to overstep my swim lanes here. And I think it would be a great question for JFO. I'm looking up the 45A report from Act 73, which is the JFO report back to you all on everything.
Yeah.
I'm looking to see if it calls out pre-K specifically. It does not, that does not mean that pre-K is not a part of the scope of work of the contractor. So that would be a question for JFO. And the intent language from Act 73 made it clear, to the extent that intent language makes anything clear, that perhaps that weight that you passed for pre-K was a temporary choice while you worked out your policy decision.
right, that's what, I think that's what we understood, yeah.
Yeah.
Yeah. Okay. All right, so that was my first question.
Okay.
And,
Now it's clear as mud.
well, it's clear what we don't understand or what we don't know and need to ask more questions about. So that's okay. And so I have that through. Okay, so does anybody else have any other questions on page 1? All right, page 2. Whatever questions I have about tuition go throughout, so, and we move back to 10. Again, we will have a consideration about whether 4-year-olds might get more, but we have to wait for JFO on that. Okay? Okay, anybody else on page 2? Okay, page 3. I was on paragraph 4. I know we had a lot of conversation about how these, how, number 3 and 4 connect, but, it seemed like in paragraph 4 in the yellow highlighted that the second half of the sentence should be first. So that it would say in any region of the state, the supply of pre-qualified private is insufficient to meet demand for pre-K in any region of the state. That, the district shall work in collaboration with AOE, AHS, and the local Building Bright Futures Council to meet with neighboring school districts, private providers, blah, 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 to further expand capacity. The district shall begin or expand a program. So we want them to meet with AOE, AHS, and Building Bright Futures. That would be the first decision point. So that should come first.
And do you want it to be so current law is there's nothing that would require school district to begin or expand a program when there's a supply and demand issue. This draft 3.1 and draft 4.1 has it as a shall. Do you want to move that back to a maybe based on the collaboration? You want to keep it a shall?
No, we want to keep it a shall.
Okay.
But through that collaboration, they might decide that this is a 1-year blip and maybe we don't need to expand. So I think that, calling upon the resources that they have available and the data that they have available. So we want them to still have the responsibility to understand that we need the capacity, if we need the capacity, if we don't have it. And we want them, to then work with these folks. And the decision point is, do we begin or expand a program or work with a private provider to begin or expand a program?
Okay.
Yeah.
So, yeah, I'm looking at that first sentence also, and I read it several times, more than once, and thought it left out something key. And I'm finally reading it and realizing it doesn't. But if it took, I'm just wondering if it needs more clarity.
Which
because
sentence are you talking
and
about?
that the first one under number 3, in terms of what the responsibility, either by operating a pre-kindergarten program within the district and I thought it said identifying a pre-qualified public program located in another district. And I said, well, we want them first to try to identify one in the district. And actually, that's what it means because it says pre-qualified private provider twice. The first one would mean in the district.
Right.
The second one would be in another school district.
Right.
But I missed that distinction like the first 3 times I read it. So I wonder if it needs to say identify a pre-qualified private provider in the district or one in another school district. Or is it just me not reading it?
You can certainly add that. It would, I assume you would want, well, I shouldn't say any assumption, make any assumptions. But should we leave it open to a pre-qualified provider either located within or?
Yes.
Yes. That's best. But
yes.
I think what Ann is saying that we want them to look within the district first. But that might
Well,
not
not
necessarily.
Because for some
parents,
right.
choice.
Yeah.
Right. So saying, that's
Both
the
are-
way you
both are
worded it
options.
is. Yep.
Yeah.
My question was about the pre-K coordinators, like we heard a lot about having them resourced, and I don't know if we should mention that. Because this just says encourage to maintain a position, but
Where's this?
how
Can
do
you point to?
oh, it's up on the screen.
On draft.
It's-
Oh, yeah, you don't
printed
see it.
mine.
Oh, right here.
Yeah.
I have it right here. Okay. Yeah. But I think it's depending upon the district. I'm not sure that we are, I guess say a little bit more. Yeah, I think. that
Yeah,
it's
so I
good, but
think, like,
they might
the-
not, I guess I'm not a full step to requiring them to have one.
No.
Can you think of about something that,
Yeah, let me think on it a little bit.
okay,
I believe, I'm sorry.
no,
Go ahead.
I believe some supervisory unions maintain this position. So that it's more of a regional.
That's what, yeah.
We can certainly we can say school districts or supervisory unions are encouraged to maintain position. You can add that in there. The slight disconnect I see is you are tying the responsibility for ensuring access to the school district and not the SU, which are two separate entities. So if it was just supervisory unions are encouraged to maintain a position, I see like why is it the SU and when it's the school district's responsibility, but you could build in both. If that is something you're interested in, or you can just leave it at school districts. It's a may, it's an encouragement. And so the education field is going to probably keep doing what they're doing.
Mhm. I think that the one thing that this didn't quite capture for me is, and I think we're just gonna keep it at school districts, is that they can work together, so they don't, so this could be
A regional.
a regional approach.
But I see the challenges of saying that in legislation, like what is it region?
I can play with the language and say, something to the effect of school districts are encouraged to either maintain a position or collaborate with other school districts in their region, which is an ambiguous term.
Yes.
Yeah. Yeah.
To ensure each school district has access to a pre-kindergarten education coordinator,
Yeah.
something to that effect.
Yeah.
That's,
Yeah, we're
That's an
wanting to,
improvement.
we're wanting to do the strong encouragement, but not requirement.
right, and not continue that, like, encourage not to continue the status quo. Like, for people to kind of,
Not to further complicate matters,
Mhm.
but the education committees are looking at those regional collaborative
Mhm.
Yeah.
bodies,
Mhm.
which could be a natural place for a
Yeah.
position like
Yeah.
this.
Yeah, exactly.
Yeah.
I mean, that's where I would see it.
Yep. Okay.
Okay, are there any other thoughts on page 3?
Really tricky to write legislation for the moment we're in.
yeah.
Right.
Yeah.
A year from now, this would be a completely different conversation.
And I think that it's, we have to, in particular, not get too wedded to what we write.
Right, we know it'll get read,
Yeah.
but
Yeah.
we're really communicating input.
Yeah.
Rather than
On
passing a bill.
page 4, I just wanted to be specific on the website of DCF and AOE, where it says publicly accessible database of pre-qualified providers.
Okay.
If we can add website of DCF and AOE. I think it says that a couple of times in here. Oh, right, all sorts of questions on page 5, okay. And I just want to make sure I understand this, the pre-qualification. You have NAEYC and at least 4 stars. So you need both of those?
No, they're or. So you only put the conjunction between the last two items of a list.
So they're all ors.
They're all ors.
They're all ors.
Yes.
I wasn't sure if the or just applied to the 3 and 4 stars. Okay. Okay, thank you. Okay, and people remember what's happening here. It's underlined here down version 3 on line 16 through 18 because we changed that later to a requirement. Okay,
Slightly new.
does anybody have
Oh, no, sorry. I'm thinking something
any
different. Never mind.
questions about that? Okay. Page 5. So I think this is one of the places where we left off in talking about registered home providers.
I have to leave and this is the conversation I want to hear.
And you were going to think more about this.
Yeah,
What are your
so I sent, so I spoke to the department and currently there's only 35 private providers, family childcare homes that are offering UPK. And then I sent an email to everybody with their qualifications. So 20 of the 35 are already AOE licensed educators. with endorsements as an early childhood educator. And then of the 15 who aren't, the current qualifications of those 15 I sent to everybody. So I think given that data, we're okay. I feel comfortable requiring the same of the family childcare homes, same qualifications.
So they're all on their way to doing this. So we would
Exactly.
give them the same
Exactly,
amount of time.
exactly.
Okay. So we're gonna require it.
So the same requirement for registered home providers as private providers?
Yep.
Okay. So we just straight through three.
A question, so the 20 have the AOE license, and we have the 15 remaining. We just said they're on their way. Do we know?
Because their qualifications are listed. So one already has a master's,
Master's,
two
right.
have bachelor's. So
And
we
they have
don't
2
know
years
if
to
they're,
do it.
Well, we're gonna give more time.
Oh, okay.
and we don't know if, you know, we don't know if they're currently continuing their education.
Right, the other 12, we don't, who are a bit further away, we don't really know. what
We don't know their status as far as like continuing, getting more,
It will become apparent. So I think that we have to remember and think about what our goals are, and we're increasing payments, and we want to have comparable education for students wherever they happen to choose where to get that education. And so
and there's already a lot of incentives and supports for individuals
and money.
and money that, yeah. So the one thing that I do want to touch on that I forgot is providing the same pathway for provisional. So currently, licensed teachers have a provisional status that gives them like a mentor and some other supports.
Right.
So we want to make sure the similar, we offer family childcare homes, individuals, the same options, pathway for provisional license.
In both center and family.
For both, yeah, for any
Yeah, for
individual
anybody,
working
yeah.
in early ed.
I'm such a Debbie Downer today.
Oh,
I'm happy to draft whatever you all want. I am not an expert on licensing in the teacher field. All of the qualifications for licenses and endorsements live in rules, not in statute. And my understanding of provisional and emergency licenses is it requires certain conditions to be in place for eligibility.
Yeah.
And some of those things are a superintendent is requesting it.
Yeah, we,
There is supervision by a licensed provider, et cetera. And so, I don't think you necessarily need to make any changes to current law if you want all of those same conditions to exist for someone to, obtain a provisional license or an emergency license through the teacher license.
because we're saying that they're required to be licensed.
Correct.
Right, so it would,
So it would
the same
follow.
things, yeah.
If you wanted to make special exceptions,
We don't.
great, then I don't think we need to do anything.
Okay.
The opportunity for those provisionals would be across the board through the current system, which is linked to a superintendent's engagement.
Yeah, I mean, I can pull up the rules if you want to look at them. I'm not intimately familiar with them. Teacher licensing has come up very little for me in my 5 years in this position.
I've experienced this process with actually a private pre-K, UPK provider and our local superintendent, and it has worked.
Okay.
I forgot about that till just now.
From a policy perspective outside of rule, do we want to say anything to encourage similar relationships?
in other words, to remove the potential ambiguity because it's in the private system.
And it's my understanding that the early ed team at AOE, this was happening until recently and something was changed, which is why it's kind of top of mind for me, where it seems not to be available anymore for
And this
early ed.
was like a couple of years ago.
Yeah.
When my local.
And this is very recently that this, so I don't know if it's something that we need to work with the department or to Doug's point, be explicit about it in statute, that we want to ensure the same pathway exists.
I'm hearing something similar, and the points I was making last week, I've had advocates talk to me have indicated this provisional process or pathway doesn't seem to be happening in the
Right,
practice.
and I think that was the internal change at the AOE that made
So it seems
that
like we need to be
change. So I
explicit
think
then,
it would
that
be
they have
helpful to
access
be
to it.
explicit that early educators have access to the provisional license.
Whether in a public or
process.
private setting.
With the same rules.
I was gonna
right?
say, as long as they meet all the other
Yeah, just to
qualifications.
kind of make sure, like, the same rules have always applied, but to
Right.
ensure that they have access to it.
Yeah, I
Just
wonder,
reference, we can say as set in rules or
Yeah,
whatever, or,
yeah.
yeah, we're not meaning to change. the
Change,
process.
Okay.
yeah, the process should be the same, and there shouldn't be any exceptions for early educators, but they should still have access to it.
I can certainly reference that here. I wonder if we should add something also back up in subdivision 4 that we were looking at about expanding access to, a regional plan to further expand capacity, which shall include the consideration of the use of provisional licenses.
Oh, that's a great
Emergency
idea.
licenses.
Yeah, that's a great idea.
There is some language that Katie paired at the end of,
Are we coming to that point?
she is included in a section D at the end.
I think this language was drafted with an assumption that you wanted to change the requirements.
Okay.
But if all you want to do is ensure that a person who is an employee of a private provider or is running a registered home program can submit an application the same as someone who's employed as a public provider and follow that same track, I don't think you need any legislative language other than that encouragement. I don't know that you need this language.
Okay.
If you want to change the requirements, like make some concessions for the private and registered home.
I think we're just looking for an equal path.
Okay.
Right, yeah.
Okay.
Who would fund it? Because right now, private sectors are probably struggling with their own finances. Would the state would the taxpayer be funding it, or would private sector?
I don't know the costs associated with provisional licenses or anything like that.
You have to pay to get a license.
Yes.
You have to pay, a person has to pay a fee to get a license, like any other license in the state.
But they
I don't know
pay
what
it, they
it was.
won't be asking the taxpayer.
I don't know enough about how that provisional
That's my
license
concern. I
process
I
works.
wrote to a superintendent to get some facts because I like going to the sources, and she said the 3-year-olds were not a good idea, and that eventually it's gonna end up very costly. And so my thing is, after getting the information from the superintendent, is who's paying for it? So that would be a concern. And she said it wasn't good for 3-year-olds, especially with Head Start. And Head Start had already told us it was a problem. Okay, thanks.
I happen to agree about the 3-year-olds, but
Yeah, I go to.
the majority of the committee did not.
Yeah, I go to the, professionals.
Okay, so I'm still on page 5 of draft 3.1, where it's talking about on behalf of a resident pre-K child. I'm the line that says, however, that the district shall pay tuition for weeks that are within the district's academic year. Act 73, aren't we moving to a common academic year?
Yes. The agency is required to come up with a statewide calendar.
Yeah, so I think we can delete that.
Okay. And that works with the assumption that all of this is taking effect with the foundation.
With the
formula?
foundation formula, yeah. Or later in the case of
Yep.
time we allow for licensure. And then I don't know if you have it in this version, about, process jointly developed and implemented by AOE, AHS, and approved by the General Assembly.
No, I don't have that, but I will. That's why it's in green. I knew that there was a decision point in there. Okay.
Approved by the General Assembly.
You want to build out any process for that or, okay. Got it.
Okay. Anything else on page 5? Anybody? Okay, on page 6. And this is where I start to have questions for, I think, JFO.
This is where we stopped.
Determining, yeah, I think I had determining average daily membership is that still, oh yeah, you got that out. Okay. That's what I thought. All right. Okay, district administrative costs. Okay. So what I don't see here anywhere is, and I don't know if it's something that we're going to get information from JFO about, is that the district, because they have a responsibility for implementing contracts and potentially a coordinator, that they need to receive some sort of administrative fee on top of the categorical.
I think we can build that into the grant payment,
Okay,
when we get there.
we'll get there.
Yes,
Absolutely. Okay. So we're moving down through this page now. We're on paragraph 4. This essentially is just saying that a pre-qualified provider or a school district, isn't that right? This is what I was wondering, because I know school districts are doing this also.
I don't know if the school, I think it depends on what the school district is offering, like,
I heard from DCF that there's, I think, 19 school districts that are combining CCFAP with pre-K so that there's a full day. And some of them are doing it by the school district enrolling directly, and some of them are doing through contracts with private providers to come into the school.
and so I would have an open question as to whether there is a cutoff at some point for the provision of pre-K, public education, and then the provision of childcare. I think if you're providing public education, charging a fee for that, I would want to consult with our education finance attorney and JFO on that. I have a strong gut reaction to that, but that's.
Well, that was my gut reaction when I was reading number 4. So I felt like if we're setting a standard for public pre-K, then that's what it is. And that in the public setting or in the public funds, this is just my personal opinion. So I feel like there should be a line where it says, we're done with public pre-K.
Yeah.
If that's 10 hours, if that's 15 hours, whatever it is. And then the next line is childcare.
Yeah.
Or after school.
Yeah.
Right,
And that's not what number 4 does.
Right.
It enables private payment for pre-K beyond what the school district receives for the 10 hours. And this is the part that is an equity issue as well. So the school
Yeah.
districts that have built it into their budget are providing it free of charge, theoretically,
I understand.
Yeah.
No, I mean, the taxpayers are all paying it.
right.
But those school districts who have not built it into their budget may be doing the 10 hours and then they
And
have
then
the
seeking
ability
additional
to
payment,
charge,
yeah.
right? And that's not
Should be
right.
standardized,
Yeah.
right, however it works, it should be.
But then we ran into the question of, well, what if there's more needs in a particular community? And, but you have to do that through the type of instruction you get during the time that you're authorized for that instruction. So we don't say, we pay them more through the weights.
Through the
But-
weights,
But we
right.
don't say
You get
you're
more
gonna, you're
hours.
gonna get more hours of school. School day is this, and we don't say you're gonna get an extra 2 hours of school because you need to learn English or, so I'm not a fan of, one district gets to put 35 hours in their budget and another school district only puts 10 hours in their budget.
You won't have that. If this takes effect at the same time as the foundation formula, that's not a thing anymore. Because there's no more school budgets in the same way we think of them now, where they are a creation of what the district values, essentially. You all will be telling them the money they have to work with it.
Right.
So I guess our question then will be, do we want to allow this seeking additional payment for whatever amount?
Because they could choose a full day pre-K and not have the resources maybe for something else that one might
Right.
offer, high school, 5 foreign languages or whatever. They would be able to choose what they value. And so they could put more into pre-K. Is that?
Potentially, I think there's some open policy questions that your other committees are working on, such as, is there more direction to school districts on what they can use their foundation payments for?
Yeah.
And we're not looking to change anything within a school district with the changes we're talking about. We're not looking to stop them from providing some service to the kids for 40 hours a week. We just want to make sure that it's dealt with separately and outside of this.
Outside of
Right.
pre-K.
Outside of
Right.
this.
Yeah, so in my estimation, number 4 would need to be changed.
Yeah.
So that they're not able to work in private arrangements for pre-K.
Section 4 only applies to private providers.
I understand.
Okay.
Yeah,
And by virtue of having your pre-K funding come through a categorical aid payment, school districts are only getting money for the hours and the kids that they have. So they're not going to be getting any money on beyond 10 hours for the number of kids they have. My understanding is that they are already able to, under current law, operate an after-school program, et cetera, and then parents can qualify for CCFAP, and then the program is pulling that in. That part is not necessarily my area of expertise, and so I can definitely consult with Katie, but I'm not sure you need a language change if you want to allow that to
I
happen.
guess what I'm trying to get at is, do we need number 4 at all? So
Oh.
We're not trying to promote additional pre-K hours beyond what we pay for in the categorical aid.
I think that may, I'm not sure that's a legal question. That may be, if let's say we struck subdivision 4, do you think that private providers would understand that then they could charge beyond the 10 hours that they're receiving from the school district? That's all I see subdivision 4 as telling private providers that, yes, you're going to get this payment from the school district, but you can also charge a family on top of that.
But we want them to charge on top of that shouldn't be for free kindergarten education.
It's for early childcare.
Yeah,
It's for the
Okay.
hours.
A child comes to room 46 and from 9 to 11, 5 days a week to get their 10 hours, they're in pre-K. From 11 after school, 11 a.m. for them is after school. So whatever
So
time,
there's-
they're in an early childcare program that's run by the district.
Right. So you
just
strike pre-kindergarten and
or
put
just
in
strike the whole
for,
thing.
right.
I mean, you could strike the whole thing because
I think that what I would do is be clear that in this case, it would be school district or pre-qualified private provider. I think that what we want to say is for those hours beyond what is funded for pre-K, you can access
the childcare
financial assistance program, and that can be done
for early education.
for early
instance,
education
not for pre-K,
services. Yeah,
right? It's for childcare.
it's for
Not
childcare.
or after school care.
And it
Yeah.
is both in the private and in the public, because
Right.
Yeah,
it's
because
happening
they
now.
each can do
They
that.
each can do
Yeah.
that. Yeah. But what? Yeah.
What happens to parents like me that wouldn't want to ask for assistance, that always, even though I was struggling, paid $70 a week for my kids to go to
Yeah,
4-year-old preschool, because I wouldn't ask for public assistance. There's a lot of people like me. So what happens to them?
well, pre-K is public education. And so, it's what we're saying is education is pre-K through grade 12. So just like you don't pay for K to 12, you're not going to pay for pre-K. You not
After hours.
after, yes, you no,
You can pay
that.
yourself.
You can pay yourself.
You don't have to apply for
Yeah,
child
you don't have
support.
to.
Right, you don't have to.
Okay, I just don't want to take that option that their child.
Absolutely not. No, that's,
Yeah, they don't.
That's not required.
Okay, because like my son would never apply for anything.
right.
Okay, thanks.
So, okay, so then the next is moving on to rules. Well, yes, I'm sorry, go ahead. No,
I wonder, and this is, I think maybe, should you choose to go through it, I'm gonna make a note for the next draft to have that language. You know, the term pre-kindergarten education is defined here, and it is not, I think section 829 is publicly funded pre-K. It is not, the definition for pre-K, here, let me scroll up, is not tied to funding. It's services designed to provide
page one.
pre-kindergarten children developmentally appropriate early development and learning experiences based on Vermont's early learning standards.
And funded by the state.
And so I think I'm just throwing this out there as food for thought. You know, this definition is for this section only, so I think you can change this definition and refer it to public funding. Or there's an acknowledgement that pre-K education encompasses or has the potential to encompass any service, regardless of the funding source, that provides developmentally appropriate early learning experiences based on VELs.
Yeah.
See what
No,
I'm saying?
I do, but no.
Yeah, but we don't want the second one. We want the first
We
one.
want the first one.
So you want to change the definition of pre-kindergarten education for this section to tie it to public funding?
Yes.
Yeah.
When will we know the public funding? Because that
Voted
could,
on it in Act 73 already.
oh, okay, so it's already there. We're not gonna ask for more because of this?
No,
Okay.
and whatever iteration comes out of the Education Committee and Ways and Means, I don't know what they're doing.
I just-
Other committees.
Because people are
And this
so
10 hours a
stressed
week.
right now.
Long precedes Act 73.
Okay.
Yes, yeah.
It's
So
just-
that's long been.
I don't want to burden the taxpayer any more than we have, then
166.
they're already burdened.
Okay, so then we're moving through rules. I only had a question on number 1. Oh, gets to that payment part again. Payments as a component of statewide tuition established under this section. I needed to understand that better.
Yeah,
I didn't understand that.
I don't know that I can offer any feedback. I think that this not make in-kind payments. I think you can certainly ask JFO. I think maybe the field would be a better resource on
Okay.
this.
So they could do fundraising essentially.
I don't understand what this is meant to get at,
Okay, so I didn't either when I read it,
which
but
is concerning, but none of us understand what this is.
it's most concerning to me that you didn't understand it. Not that we didn't understand it. Okay, we have just 5 minutes to get to the floor, so we should probably stop here, but
After 1 page, 1.5 pages.
well, we did
I
a lot of
know.
other stuff, and
I
then
know.
we have Doug's proposal to consider as well. And a lot of this is actually, it feels like it's very prescriptive when it comes to what's in the regulations to me,
Yes.
and considering what we normally say about regulations in our
You mean the
committee.
rules?
The rules, yeah.
Okay.
The rule,
Yeah.
the rules, it's very prescriptive,
Yeah, I
and
wonder if
so
we can
I,
remind that.
I wondered about that, to be honest. And could you see if you could find the rules and see if it actually does all this stuff? Um. So that, it was just a question for me. It was. I'm sure it was done that way for a reason and I just, it was a new program at the time and.
Well, and we did something like with stars back in 23 when we changed it. The original star statute had all the rules in statute. And with the revision, we pulled them out and put them in rules.
Mhm.
So every time we wanted to make a change, we didn't have to go through a legislative change.
That's what I mean.
Yeah, so I think this is like.
I feel like it's overly
not-
prescriptive.
Exactly. I think it's a good exercise to do, to find out what can be pulled out and put in rules. So if things, and I can find out from the administration, like how often are these changed? Like, do you need flexibility to be able to change?
I can tell you that.
Yeah.
Yeah.
Never, the rules are never changed.
That's why I want to make sure do they actually have them that cover these areas? I don't know the answer to that. Okay, yes. We're back at this at some point. I don't have my schedule right in front of me, but,
Well, we have
Not today.
right, because we have the 567, 657.
yeah, 657 amendment.
Should I send that email to everybody, as the heads up to the one section on state's attorneys and,
Any background information that you have would be a good idea.
I'll send that.
Yeah.
So
So,
that's the one discussion point.
so after floor, we're going to do that amendment. Floor is going to be long. If we have additional time after we do the amendment, we'll come back to committee discussion on pre-K and we'll talk about Doug's proposal. Okay? All righty. Thank you.